Thanks for joining me. Hi, everybody. I'm just taking a few minutes here to let a couple folks join us. I apologize, I got started just a minute late today. Hi. Welcome, everybody. It's nice to see you all for another month of immigration lunch. I guess we could call it that. Lunch with an immigration lawyer here at Boundless Immigration. I am immigration lawyer and immigration policy analyst for Boundless Immigration. My name is Maggie Riley. So I'm really excited to have another conversation with y'all this week and give everybody some updates about what's happening in our immigration system. So I'll take just another moment here to let a few more of our friends join us, and then we'll jump on in. Hi, welcome folks. We might be hitting about our tipping point to get started, so I will go ahead and do that. So for those of you who have just joined in the last couple of minutes, my name is Maggie Riley, and I'm the Immigration Law and Policy Analyst for Boundless Immigration. So I'm an immigration lawyer by training, and I've been working with Boundless for about 3 years now to give information about the U.S. immigration system. And so today we are going to talk about processing times, which are always a hot topic with immigration because we know how slow our system can be. We're also going to talk about the green card backlog at the NVC, or the National Visa Center, and then I'll give y'all some updates on what's happening in Congress with legislation to help immigration move forward, as well as what kind of lawsuits we're seeing happening in our court system. So I am based in the United States. Boundless Immigration is also based in the United States, but we help people immigrate to the U.S. Largely through the family-based immigration system. And that has always been my area of specialty as a lawyer. I worked in private practice before I came to Boundless, and now my job is to help make the immigration system more understandable. So for those of you who have joined us, I am going to be giving some updates on legislation, litigation, which means lawsuits in the courts, and processing times. And then if we have some time at the end, I'll take some questions as well. Please keep in mind that though I'm an immigration attorney, I can't give specific legal advice to anybody about their case. I can only give general information about the immigration system and about how the law works, but I'm not able to answer direct, specific questions about your individual case. So with that all said, I will go ahead and get started. Thank you everybody for joining me. So today it is August 18th. We're about halfway through the month of August. And at this point, Congress is in recess. So I'm actually going to start with processing times, which always feels like it's kind of the hot topic everybody wants to hear about. Unfortunately, we're not seeing a lot of movement in USCIS processing times. In fact, if anything, we're seeing them get a little bit longer for certain cases. So USCIS releases their service-wide forms report. And what that is a document that lists every kind of application or petition that USCIS receives each quarter. They divide the fiscal year into quarters, and it actually starts in the previous year. So the USCIS fiscal year starts in October, on October 1st of 2021 for this year, and will run through September 30th of of 2022. So that's going to be coming up in just a month here. During this time, USCIS is supposed to release these service-wide reports each quarter, which is approximately every 3 months. Unfortunately for us, the last time USCIS released this document was only for quarter 2, which ended on March 31st. Obviously, we're now in the middle of August, so about 6 months have passed since we've gotten updated data from USCIS about how many cases they actually have pending in the backlog. Based on the data we got in March, we are seeing that there's still over 1.6 million cases in the backlog, and that's across all kinds of immigration forms at USCIS. That includes family-based immigration cases, employment-based immigration cases, asylum cases, green card renewals and replacements. It's across the whole system. So we're looking at a really large backlog number. In that case, though, we are seeing also a 43,000 case backlog in K1 I-29F petitions, and the 1.6 million I-130 petitions are in the backlog. I misspoke earlier and said that the complete USCIS backlog is 1.6 million. In fact, is unfortunately quite a lot larger than that. It is 8.5 million. So very sorry about that. I-130s, we're talking 1.6 million in the backlog. Now, again, it's been a few months since we've gotten new data from USCIS, so it's possible that number has decreased. But it's also possible that number is increased, and we won't really know until USCIS releases the Q3 data, which should run through the end of June 30th. Hopefully we'll see that data in the next few days. In the meantime, waiting for USCIS to release their forms reports, we are still able to use their processing times website, which I'm sure many of you have had the opportunity to use, unfortunately. Now, the USCIS processing type site can be a little bit frustrating because it doesn't give an individual processing time for your case. Now, it does give individual processing times for case types. So you can find the I-130 processing times, but it's going to be the number that 80% of cases are finished in. So it won't be your individual I-130 case. It will just be how long does it take USCIS to process 80 or complete 80% of their cases, so the majority of their cases. What we found is that for Form I-485, which is the application to adjust status to permanent residency, so that's the green card application for folks who are living in the United States, and is also I-130s for U.S. citizens, relatives, and for F2A, which are the spouses and children of lawful permanent residents. We've actually seen that those processing times are trending slightly upwards over the past 6 months. And so, unfortunately, that is not great news. We'd really like to see that moving in the other direction. Right now, we're looking at I-485 processing times are averaging for 80% of cases about 16 months. But you do have to keep in mind that that number is going to vary depending on where in the United States you live. So, for example, here in the Seattle area in the state of Washington, our USCIS office has quite a long processing wait time for Form I-485 interviews that is substantially higher than 16 months. Other states or offices, however, might have much shorter processing times, and you may see an interview scheduled in perhaps, say, 8 to 10 months. It is going to vary depending on where you lived, but overall, we are seeing a slight uptick in how long people have to wait to get to their green card interviews. Now, for K-1 fiancé petitions, the Form I-129F that is submitted to USCIS before you go through the consular step, we're actually seeing those trend downwards over the last 6 months, so that is good news. Right now, we're seeing about 8 months as the average sort of 80th percentile time frame for I-129Fs to be processed by USCIS. So good news for K-1 fiancé petitioners. You're going to see those times hopefully starting to trend down. On the other hand, though, you do have to remember that with the fiancé visa petition, there's always going to be that second step when you're dealing with the Department of State and the consular offices. So the USCIS approval in 8 months is just that first step of your process. On average, we're seeing about a year from the time that USCIS approves the I-129F petition through the time your fiancé is actually going to be able to attend their interview and then receive their their visa packet to enter the United States. Again, similar to the I-485s inside the country, you are going to see some variation in timeline there. Some consulates are moving much faster than others. We have seen scattered reports of certain ones that don't seem to be moving at all. And so it is a little harder to pinpoint exactly how long those are taking. But for the I-129F at USCIS, the good news is we are seeing those initial petition approvals happen a little bit faster. So that's about where we're at on USCIS processing times. Hopefully we'll have some more data from them in the next couple of weeks, but there are no guarantees, unfortunately. They seem to do things sort of in their own time. Now, turning from USCIS, I just mentioned the NVC, which is part of the Department of State. The NVC stands for the National Visa Center, and many of you have probably heard me talk about this before. The NVC takes over case processing for folks who are entering from outside the United States after USCIS issues their first step approval. So, for example, in a K-1 case. The NVC's job is to essentially help the DOS gather the documents from the applicant that they need before they will schedule the interview with the consulate or embassy. The NVC does release a backlog report each month where they track the number of cases that are ready to be scheduled for an interview at the end of the previous month, how many interviews were scheduled during this current month that's just started, or in this case that we're just in the middle of, and then how many cases are left in the backlog after all those interviews is scheduled. So when we looked at this data, it was just released a few days ago, about a week ago. We did see that, in fact, the backlog of cases in that at the NVC for green cards is actually fallen by 6%. Now, this is a single-digit percentage point, so I understand that doesn't sound super exciting, but we're talking about just under 33,000 cases that were cleared out of the backlog last year. However, when we started digging into this data, we did notice something else appears to be going on. And it seems that fewer cases are actually being entered into that initial pipeline to be scheduled for interviews in the first place. So to explain how we determined this, we took a look at those three figures that I just described that NVC releases. We have the cases that were ready to be scheduled at the end of the previous month, the number of interviews scheduled, and then the final backlog. As we go back and look at the final backlog number and the number of cases ready to be scheduled on a chart, we can see that those numbers are falling in tandem with each other. So as one falls by, say, 15,000, the other one falls by about 15,000 as well. And so if you're looking at a graph, these numbers are following just in mirror image to each other. Now, that wouldn't seem unusual, except that if you look at the same graph and add on a layer that shows you how many interviews are being scheduled, we see that that number of interviews being scheduled is actually staying pretty much the same since April of 2021. And we will post some graphs, so if you guys want to look at this later, we'll also share the links to the report so you can see the graph in picture and know what I'm talking about. But essentially what I'm describing to you is we have two lines that are falling this way and one line that should be rising to meet them, right? If this line is falling because of interviews, then the interview number has to go up. That isn't happening. We're seeing interviews staying about flat. There's been some variation of a few thousand interviews each month, but NVC in general, on average, is scheduling about 24,000 interviews per month. And so we haven't really seen that change. And so while it appears that the backlog is falling, it seems like, for lack of a better phrase, that the NVC is cooking the books a little bit to make it look like better news than it really is. Because, of course, we know that people are continuing to submit cases to the NVC. USCIS is continuing to approve cases and send those to the NVC. And so as those cases become what is called documentarily complete, which means they're ready to be scheduled for their interview, we should expect to see this number falling more rapidly. But unfortunately, that's just not what we're seeing. We're going to keep our eyes on this over the next couple months. There's a couple immigration lawyers out there who have started to spot some of these potential discrepancies. So we'll keep you updated as we learn more about what's happening, but hopefully we'll start to see more aggressive reductions in the green card backlog at NVC as we get closer, very close now to the end of the year. USCIS has indicated that they want to use all the employment-based visas that are allocated this year. Because the year for the government ends on September 30th, which is only about 6 weeks away, it's not guaranteed that they'll be able to do that. Myself personally, as recently as a month ago, said I didn't think it was possible. However, it does appear that they're on track to do that, at least according to USCIS. So hopefully by the time we get together for lunch next month, we'll know a little bit more about how USCIS and the NVC are tackling these backlogs and how many of those green cards they're actually going to give out before the end of the year. So, and now that we've talked about the most exciting NVC backlog and processing, I wanted to touch a little bit on some of the legislation and some of the litigation that we've seen happening around immigration. So some of this is going to be a continuation from our chat last month. As I'm sure will surprise very few people on this call, Congress does not always move especially quickly. And so while we have seen some bills passing out of the House and Senate and being signed into law by the president over the last couple of weeks, very few, and in fact, I would say none of them have contained, in fact, yes, none of them have contained any immigration provisions. The CHIPS bill had passed. That had originally contained several immigration provisions that were meant to assist STEM applicants, folks with PhDs in research, and other immigrants in those sorts of fields to be able to have more expanded routes to getting green cards or to working in the United States. Unfortunately, though that bill was passed, the immigration provisions were stripped out of the bill, and so we didn't see any gains from that bill. The Climate, Health, and Infrastructure Bill, which has gone on to be called the Inflation Reduction Act, also was passed last week and then was signed into law by the president on Monday. That bill also did not contain any immigration provisions, but there was concern before the final vote in the Senate that some senators would try to add anti-immigration provisions, knowing that there were members of the Senate in the Democratic Party who had difficult re-election campaigns ongoing and could be potentially convinced or strong-armed into voting for some of these anti-immigration amendments to show that they're tough on the border or to appeal to more centrist or right-leaning voters for which immigration is more of an issue. We were able, the bill did pass without any of those anti-immigration provisions being attached. The major ones had been provisions to make Title 42 permanent, which, as a reminder, is a bill that essentially prevents immigrants from claiming asylum at U.S. ports of entry, as is required by American immigration law. The bill has been Title 42 has been caught up in litigation, which I'll touch on in just a moment. But the amendments that some senators attempted to add to the Inflation Reduction Act to make Title 42 permanent did not pass. And so that bill did go into law with no additional border wall funding, no Title 42 extensions, and none of these other amendments that some of us had been concerned might sneak into the bill at the end. So that was good news on the immigration front. Now, DACA is another one that has been kind of hanging out for a while. It's got a lot of people on edge, of course. It impacts over 700,000 people who are living in the United States with that status, folks that by and large are Americans at this point. So it's a huge impact, but the Fifth Circuit did hear the oral arguments on July 6th. So we're still waiting for them to issue an opinion. It is expected essentially any day now. The Fifth Circuit did not appear particularly inclined towards the government's argument to save DACA. And this is not necessarily surprising. The Fifth Circuit Court of Appeals is based in New Orleans in Louisiana, and it covers the surrounding states in that area. So Texas, Louisiana, Mississippi, etc. And the Fifth Circuit is frequently cited as being sort of the most conservative appeals court in the United States. We've seen a lot of decisions that have not favored immigration or immigrants come out of that circuit. And so my own fear, unfortunately, is that we are going to get a bad decision from DACA from the Fifth Circuit. However, the Biden administration has stated over and over again that they prioritize this, that they have a rule that is supposed to come out, and that they're attempting to defend and fortify DACA. And so we do expect that if this negative decision comes out of the Fifth Circuit, the Department of Justice under the administration will take it to the Supreme Court. At that point, it's a little more of an open question how the Supreme Court would rule. I don't want to go too far out on a limb there yet, but I will say that we are expecting that decision from the Fifth Circuit any day now. And so we'll be keeping an eye on that and let you know if we do hear anything further. But at this point, it's been very quiet out of the Fifth Circuit. In terms of other litigation is the Title 42 case. Now, this one's been a bit of a mess. It's gone back and forth. And it is still tied up in the courts based on decisions out of a federal court in Texas in Amarillo. So we are waiting to see what will happen there. The states of Texas and Missouri, who originally launched the lawsuit to force the government to keep Title 42, refiled their complaint. And the complaint is that first level document that a party files in a federal lawsuit. So they have to file a complaint in federal court. In this case, it was sent back down, and so Texas and Missouri have updated their complaint, and they're refiling, and essentially the litigation will go again from where we were at. So we are not expecting to see a resolution to that case in the near future. Remain in Mexico, however, was a win on the litigation front. The Supreme Court did rule that case, that the Biden administration could end the Remain in Mexico policy. That's formally called the Migrant Protection Protocols, and this was a policy that was started in 2019 under the Trump administration that required asylum seekers, even those who were not Mexican citizens, to wait in Mexico for their U.S. immigration court hearings. So that case was decided by the Supreme Court. Once they certified their decision, they sent it back down to the lower court, who vacated their original ruling. And so now at that time, the Biden administration is now able to wind down the program, which they announced they were doing about 10 days ago. So there will still be some winding down that the Department of Homeland Security will have to do to make sure that everything is sort of tied up and put a bow on, that people who were sent out of the country can come back for their dates in court. But officially, the administration has signaled that that policy is now finished. So that is where we're at on our lawsuit updates. By and large, it's a lot of wait and see. We're still just watching things drag their way through the courts. And this is true for a lot of the diversity visa litigation as well. So finally, I'd like to turn to what's happening, or turn back to what is happening in Congress. I took a little detour there. So there are three bills that are dealing with immigration that we could still see potentially working their way through. Excuse me, I said three and I meant two. The first is going to be the Farm Workforce Modernization Act. I'm going to just call that the Farm Act for now, so I don't keep stumbling over my words. But the Farm Act has passed the House of Representatives twice, but has been stuck in the Senate for quite some time at this point. The bill is largely focused on updating the food production workforce in the United States. And this is a system that many people feel is outdated, and sort of food security economists in the United States have drawn a connection between high food prices and inflation and the shortage of immigrant farm workers and farm workers in general. However, in the United States, the farm industry is extremely reliant on immigrant workers, especially those that are part of the H-2A program. So, the Farm Workforce Modernization Act, or the Farm Act, is aiming to sort of modernize this system by allowing more farmers, particularly in industries like dairy and pork production, to hire H-2A temporary workers year-round. Currently, under law, they're limited to temporary employment. The Farm Act aims to expand that to allow people to work, more people to work longer. However, Senate negotiators, as I said, this passed twice in the House, ended up in the Senate about a year ago and has just been sitting. So Senate negotiators are stuck on some provisions about who can file lawsuits for labor law violations. Currently, H-2A visa holders are not able to do that. The House-passed version of the bill would open up this possibility to them to enforce their labor rights under U.S. law. But there is some sticking and arguing about that in the Senate. And so it's not clear if this bill will make it through the Senate process and be finalized before the end of the fiscal year in September 30th. The American Farm Bureau Federation has been lobbying towards this, but there haven't really been any updates since about 3 weeks ago as to what the exact status of this bill is. However, we do know that time is running out as we approach the end of the fiscal year in September. And if Congress doesn't get this done, they're really going to miss what's a very good opportunity to help tamp down runaway food prices in the United States. Of course, we've all seen this in the news. And so there's a great opportunity here, but only if the senators in Congress make it happen. So like the other bills that we've discussed here, we will be keeping our eye on this. This would be a huge win for a lot of people, including those of us just trying to do our grocery shopping. So hopefully we'll hear a little bit more about that in the following 3 to 4 weeks. The other major bill that we're seeing that could hold immigration provisions is the National Defense Authorization Act, and we discussed this one last month a little bit as well. The NDAA is an annual bill that's generally considered to be must pass, in that this is the bill that sets policy for the Department of Defense and the Pentagon, but also appropriates their funding and the money on which they function. So it has to be passed every year so that Department of Defense programs can start up uninterrupted on October 1st. At this point, the NDAA is probably, besides the Farm Act, the best chance of getting any immigration provisions through Congress. Since they weren't able to get any immigration provisions attached to the Budget Reconciliation Bill, which was the Inflation Reduction Act, that's going to leave essentially just the NDAA as our primary method of getting anything done on immigration this year. Now, the amendments that are included in this bill are generally popular across both parties. So there's a provision to protect documented dreamers, which are folks that entered the U.S. Legally on visas and then later had their status expire or aged out of their visa. And there is also, there is also a provision for Afghan refugees, and this was also to help folks that had assisted folks in Afghanistan, had assisted the U.S. forces there, would allow them to more easily obtain their special immigrant visas and enter the United States where they would be safe. There is also an amendment included that would benefit Afghan students, making it easier for them to obtain student visas to study in the United States. Finally, an additional provision that had been added but then was dropped was to help favor STEM degrees in national security. That one did not make it to the final version of the House NDAA bill, but the documented dreamers provisions and the provisions for Afghan students and SIVs, special immigrant visas, did both stay through the House bill. The House voted by about 3-1 to approve the bill, which is a great sign. But as we know, the Senate can be a really difficult place to get legislation passed. And so it's hard to say exactly which provisions will still be in the bill when it finally does make its way into the Senate votes. Again, time is running out. The Department of Defense is really pushing for this to get done before September 30th, because if it is not, the Senate will have to pass a continuing resolution to keep the government open and to keep the DoD funded. And in general, that is not popular with anybody, and so they're really hoping to see this pass before that. So finally, one really exciting piece of news too, touching on Afghan folks who helped the U.S. in Afghanistan in the fight against the Taliban, is that earlier this week, an Afghan Adjustment Act was introduced. That was introduced on August 9th, and it was introduced by a bipartisan group of senators and representatives. And this bill would create a pathway to permanent residence or green cards for about 76,000 Afghans who were evacuated to the United States after the fall of Kabul in August of 2021. So these evacuees had been allowed to enter the United States on humanitarian parole, but this doesn't grant them a permanent status, and it doesn't generally it doesn't often allow work authorization on its own, though for many Afghans it does. By giving them a path to permanent residency, this will allow more people to regularize their status without that concern about what's going to happen in the end of 2 years. Given that the situation in Afghanistan is still quite dangerous for many people, there was a huge explosion in a mosque in Kabul a couple days ago with many people killed. We would hope that we'll see this bill pass so that these individuals can gain permanent residency and integrate into their lives here, get jobs, live without concern of what's going to happen in a year or two when their parole status runs out. The bill is popular across Republican and Democratic members of the party, but it's not guaranteed that we'll see it pass. There's been talk about an Afghan Adjustment Act for essentially a year since the fall of Kabul last year, but we have only just seen it be introduced. So we're hoping that this could pick up steam, but again, it's not guaranteed that we're going to see movement on this in just the next couple weeks. So those are the major bills that we have moving right now in the House and the Senate. There's nothing, besides the Afghan Adjustment Act, there are no, which would help a fairly large group of people. We don't see any major immigration reform upcoming. And so it's a little bit tricky to say what's going to happen in the following year because the midterms are coming up in November. And it's hard to say right now exactly how the balance of power will change between the Republican and the Democratic parties in both the House and the Senate. Generally speaking, the Democratic Party tends to be more in favor of passing immigration reform or provisions that benefit immigrants than the Republican Party. And the Speaker of the House, or excuse me, the minority House leader for the Republican Party, Kevin McCarthy, has said that he will not put any immigration bills on the floor if the Republicans take control of the Senate in November. So we're going to keep our eyes on this. There's a lot of intersecting parts here. But at this time, that's sort of where we're at on legislation in Congress and what's going on in Congress. So I just wanted to take a quick moment and just see if anybody had any questions about any of those bills. If there's anything there that I can answer related to that. And then remembering, of course, that I can't give legal advice on individual questions. I'll also say that we will be posting this live so that it can be viewed again later if you had to leave early. And we will also post links to some of the resources that we discussed today, like the NVC Backlog Report, the National Defense Authorization Act, and a few of the other topics we discussed. So I am not seeing any questions come through the chat. So I'll take just a quick moment here, but I think we're going to be wrapping up in just a second here. If you have more questions, you want to learn more, you like to read about immigration, you can go to boundless.com. We have a banner across the top where you can sign up for our Boundless Immigration Toolkit. And this is our weekly newsletter about major news happening in the immigration space, a toolkit with tips on various immigration processes that you can do, and hacks, tips and tricks, let's say, as well as some good news that you can read about immigration. So I am seeing a question, I-129F currently 13 and a half months. So that's going to have a lot to do most likely with what's going on with the consulates. So we are seeing that USCIS is approving those more quickly. We've seen the number drop to about 8 months. But one of the big issues there is that once USCIS approves the I-129F, they transfer it to the National Visa Center. And this process can take anywhere from a couple days to a couple months. Once the National Visa Center has it, they collect documents from the petitioner and the applicant. And then they work with that consulate to schedule the interview. Unfortunately, some consulates are still running pretty behind after what happened in 2020 with the pandemic shuttering so many offices. And so there is pretty large variation there, unfortunately, but I would say that in general, we are seeing I-129Fs take a little less time at USCIS, but those higher processing times are going to be due to the additional steps that are taking place after USCIS. NVC gathering documents, they run background checks, they make sure everybody is who they say they are, they're cross-referencing your documents. So all of these steps are taking place in the background, sort of away from our site. And so that does, unfortunately, add a bit of time. Unfortunately, I'm not able to give a precise answer based on the consulate, but I would say for fiancé visas like the I-129F, that's going to be a big part of the reason is a lot of consulates are still pretty understaffed, or if they're back up to their pre-pandemic levels and processing, they're still making up for lost time. So unfortunately, it's probably going to take some time to start really seeing those numbers come down. But in general, fiancé visas we're seeing trending in the right direction, at least as opposed to CR1s and CR6s. Now I saw, let's see, applied for... I see some questions about O1 visas and TN visas. Sorry, thank you for pausing while I went back and read a couple questions. So in general, USCIS is not going to approve an applicant for more than one status. And so in my personal experience, we would see this come up with, say I had a client who applied for asylum. And they also, while they were waiting 4 or 5 years for their asylum case to process, they were going to school, they met an American citizen, they fell in love, and they got married. Through their spouse, they decide to file a green card application, and that actually gets processed much more quickly by USCIS than an asylum application. So they have an asylum application pending, and they also have a family-based green card application pending. If one gets to an interview date before the other, in general, what that applicant or the attorney can do is say, and I had USCIS ask me, what are you going to do if one or the other of these is approved? And sort of the subtext is that they're not going to approve both, right? You either are going to become an asylee and have your asylum case approved, or you can become a green card holder based on your marriage to the U.S. citizen in this hypothetical example I'm giving. So if one has been approved for an O1 visa, it's unlikely that USCIS is going to approve a second visa without ending the first status. Now, that might not be strictly true, but in general, USCIS is only going to approve one status per an applicant. So if someone is interested in switching between visas, that's something I highly recommend speaking to an immigration attorney about, especially when it comes to the TN visa, which is our visas for NAFTA professionals from Mexico and Canada. The rules for TN visas are pretty strict. Only certain jobs fit into the TN visa categories. And TN visas also do not allow immigrant intent, which can make it harder in the future if for some reason somebody wants to change to, for example, a green card. So there are a lot of questions that go into whether somebody wants to switch between visas or not, but I would strongly recommend that you consult an immigration attorney who can give you advice about specific details in your case. Can you sue USCIS for overpassing waiting time? So, yes. And there are attorneys who specialize in this. I would say that I believe these fall under the mandamus litigation. So mandamus means essentially forcing the government to take action on a case. These usually have to be filed in federal court, and you usually have to show that it's, obviously it has to be outside the processing times given by USCIS, which unfortunately those times are very, very long. And so the setup to be able to file a lawsuit can be quite long. I will admit this is not something that I have worked personally on. I have not, I don't do federal litigation. And so, but there are attorneys who do specialize in suing the agency to get them to process cases, issue green cards, issue visas. It's actually its own niche area of immigration law because sometimes, unfortunately, it can feel like the only way to get USCIS to move on a case. So there are different avenues that this can be done in immigration law, depending on what the issue is. But in general, yes, you can file a federal lawsuit over a case if USCIS has overshot the waiting time, but not for any case. And there will usually need to be sort of, you'd have to show sort of what the harm is and why this needs to be, tackled. So somebody asked about a fiancé visa. Sorry, I'm scanning questions, y'all. So it looks like those are the main ones I got. How long to take to renew an employment authorization? This is a tough one. This is going to vary a lot across the type. So if you have an employment authorization document, which is an EAD, in general, renewals on those, I'd like to say, are sitting at about 8 months right now, but we've seen even longer. Folks who are applying for EADs based on an asylum case, their EADs are supposed to be processed in, gosh, it might be 30 days. I don't want to misspeak, but there's a legal time limit to when USCIS needs to have made a decision on these cases, and it regularly misses these targets. So the employment authorization document backlog has been a huge problem at USCIS. In general, the best practice had always been for immigration attorneys to talk to their clients and tell them, and in fact, the U.S. government said, don't file your EAD renewal more than 6 months before it expires. Unfortunately, as we saw those EAD wait times get longer and longer and longer, that didn't become possible because what was happening is people were waiting until 6 months before their EAD expired, following the rules, filing their renewal, and then not getting an answer until after their green card had expired. However, despite the backlogs that we're seeing in EADs, which at one point it hit nearly a year, I do believe that we have decreased from that point, but you're certainly looking at more than 6 months in most cases. The one upside here that we are seeing is that USCIS did update their policy to allow an extended period of validity on your EAD given by your receipt notice. So if you already had an EAD previously, as long as you show that you timely filed your renewal, which means you filed your renewal application before your current green card or EAD expired, then the receipt notice that you get from the government showing that, yes, I filed my renewal should function as employment authorization proof going forward. And I believe that you're looking at over a year that will be valid. So we're hoping to see some updated numbers again from USCIS in the next couple weeks about how big that EAD backlog still is. Last we had heard from the government, it was exceptional, hundreds of thousands of cases. And so we're really hoping that we're going to see that number has come down. If you're worried, though, do just make sure that you are filing renewals. Everybody should be filing their renewal before the expiration date. Get that receipt notice from USCIS, and that will allow you to continue working. Taking a peek back through the questions. I see a question here about getting a DUI during the statutory period and whether that can stop somebody from getting their N400 approved. So this question is pretty nuanced. It's going to depend on the facts of the case. The statutory period means the 5 years immediately before you apply for citizenship. In the citizenship context, they count that as being when you do your interview. And so they're going to count backwards from 5 years and look at your employment history, your address history, and then also if you have maintained what is called good moral character. Now, a driving under the influence charge in general is not considered what's called a crime of moral turpitude, and it doesn't necessarily mean that somebody does not have good moral character. However, it can substantially increase the scrutiny and difficulty of the application case. In general, many immigration attorneys would probably recommend that somebody who got any criminal charge during the 5 years before their citizenship application wait to do their application until that charge drops off the 5-year statutory period. Now, everybody's case is different, and citizenship is an incredibly important, exciting thing to be working towards in your immigration journey. I used to love doing citizenship cases, and so I would highly, highly encourage anybody who has concerns about their citizenship application to talk to an immigration attorney who can talk with them about their specific case. Just because you want to make sure that you're going in with all your ducks in a row, that you're ready to go, that you don't get surprised by something or tripped up by something. So a DUI, certain other crimes that are not felonies aren't going to necessarily stop someone from getting citizenship, but they can make it harder. So you want to make sure that you talk to an attorney and get really solid advice. But for many situations, the safest course of action could just be to wait until that statutory period is over. How long is it taking to get a receipt number? That is a variable question. We were seeing huge wait times for receipt numbers over the past year, sometimes in excess of many months. I have not heard that is still true. From what I am aware, they're trending back down to closer to 30 to 45 days. However, I realize that I haven't checked specifically on this issue in the last couple of weeks. So that's something, thank you, I'll have a look into, and we'll see if that is still an issue. Like I said, for a while in 2020 and early 2021, we were seeing it take months to get receipt notices, which of course can make it really difficult for people to show that they have applications in process, to prove their work authorization. Now, before the pandemic, and I would say even into 2019, receipt notices took about 2 weeks to show up. And that used to be the general standard, that you'd expect to see a receipt notice between 1 and 3 weeks. But of course, it's the government, so it could always take a little bit longer. However, at this point, I would say that you don't probably need to panic until after you're outside that 30-day period. The government is just running quite slowly. They keep changing the filing addresses for things like the I-485, and all of these small changes can really sort of add hiccups into things that unfortunately just make the processes take longer for the applicants who are on the outside. Visa appointments at foreign consulates. Wait times for these are really, really long. I see a question in the comments here about a fiance who's waiting for a tourist visa appointment in Nigeria that's not scheduled until 2023. I can say that Nigeria in general has always been a very active embassy, U.S. embassy over there, and that we do receive many immigrants. It's a very busy consulate, and so I would guess that the reason that these interviews are so far out is based on just how much activity, how many people are applying through that consulate, and also catching up from the past 2 years when the consulate was essentially closed, or the first, at least during 2020, when the consulates were all essentially closed. So the other issue there is that the government is prioritizing certain interviews. So family-based interviews for green cards, employment-based green card interviews, those are being, and fiance interviews are in general being prioritized over other kinds of interviews such as tourist visas. So without working in the embassy there, I can't say exactly what's going on behind closed doors, unfortunately. But a best estimate would be is that there are already very long backlogs, unfortunately, and wait times at a lot of embassies around the world. But also just that the government is tending to prioritize different sorts of visas. And so tourist visas, unfortunately, are getting short shrift compared to others. As far as ways to get sooner or closer appointments, in general, it's really hard to move a interview at a consulate closer in time. It is possible to reschedule to a later date. Moving them earlier can be really challenging without showing that there's some really, really extremely serious reason that this needs to happen, like a medical emergency. If you have reasons, a reason like that, if there's something really specific that you think could help that case be moved forward, then that's something that most likely you would get results, more likely to get results if you're able to work with an attorney who's specifically familiar with that consulate. But unfortunately, as I said, moving those interview dates forward to a sooner date can be really, really challenging, if impossible, unfortunately. I do see a question about what does it mean for a case to be actively reviewed? Actively reviewed is great news. Congratulations. So USCIS puts up a series of updates on their website. When you punch in your case ID number, it will let you know my case has been received, we've processed your biometrics, your case is ready to be scheduled, which is one that I'm sure some of you have seen many times. It can hang out there for years. Essentially, my case is ready to be scheduled means they've received your application, they've done their first round check, and to make sure that everything looks good, that you've provided all the documents you're supposed to. And then the case sort of goes into a holding pattern until the office that will conduct the interview will be ready to proceed. When the case is being actively reviewed, what that means, or what that should mean, is that the case has been transferred to the place where the interview will happen, and that the person who will give the interview is, have a guest, I'm so sorry, excuse me. The person who will be giving the interview is actively reviewing the file to prepare for the interview. So in general, and keeping in mind that we never really 100% know with the government, usually for myself, if I were an attorney and I saw that my client's case were being actively reviewed, I would think that was a good sign, and I would start keeping my eyes on the mail to see if I was going to get an interview notice. So hopefully that's what's happening for you, and you've got some good news coming your way soon. I see a general question about Boundless, the company, and how it works. We are an online company that helps people file their immigration paperwork. Predominantly, we work with families of U.S. citizens and green card holders, but we've also just launched a student visa program, and we're expanding our programs into other fields as well. My main goal working here at Boundless is to make sure that the immigration system can be more accessible and more understandable to those of us who need to use it. The government websites can be really difficult to understand. A lot of the information that is out there about the immigration system is written by other attorneys for other attorneys, which can make it difficult for regular non-lawyer people to understand all that jargon. And so what we really hope to do is make the immigration system more understandable and hopefully one day easier to navigate. If you check out our site, boundless.com, we have tons of resource articles, how-to guides, things that you can use for your research. But of course, we also have ways that you can also look into helping bring your family into the United States, getting your own green card, renewing your green card if you already have one, and some of these other programs. So please do check out our site. You can sign up for our newsletter there to get weekly updates about immigration news and just generally learn more about what's happening on in the system. I absolutely agree. Our immigration process is outdated and backlogged. So I am getting a little bit close to time here, so I'm going to take another question or so here, and then let's see what we've got. So this question I see is about someone who was a green card holder who filed for their wife to get a green card as well. So usually this would be what we call the F2A preference category. So that's the family second preference category, and that's for spouses and children of legal permanent residents or green card holders. So in general, a U.S. citizen, if an LPR files for their spouse to get a green card, and then the LPR becomes a U.S. citizen while that case is waiting for their spouse, you can do what's called an upgrade on your petition. And so that is essentially you'd contact the government, probably USCIS, but I'm just assuming. You're going to contact the government and let them know that, you know, the case has been changed, that the petitioner is now a United States citizen, and then ask that they upgrade that petition. Historically, people who were spouses of U.S. citizens did have their cases processed more quickly. Unfortunately, and for reasons that pass understanding, currently it is actually faster for some green card holders to sponsor their spouses than for U.S. citizens. That's kind of an unusual development that we've seen sort of crop up in the last year or two, and it's not entirely clear why it is that that's happening. But it is possible to upgrade a petition, and theoretically the U.S. citizen spouse immediate relative petition then should be processed more quickly. However, it's going to depend on which USCIS service center is working on the case, and that can really change things a lot. So there's not really a firm answer that I can give about whether it will actually be faster for a U.S. citizen versus a green card holder petitioner. But in general, because it is possible to do that upgrade. And in the past, that is frequently what I would have done for certain cases. But again, every case is going to be different. And so if you are not sure what the best course of action is, I really recommend that you talk to an immigration attorney in your area who's going to be familiar with what the wait times and the processes are like at your particular field office. All of these things are so specific to everybody's case. And so just remember that nothing I say here is, a solid answer to an individual question. This is going to be general information to sort of help you on your way. But I do hope that does speed up the process for you all. Does it speed up the process if your spouse is in the military? It can. There are specific processes for U.S. service members who are petitioning or sponsoring their spouse, who are removing conditions on their spouse's green cards, and also for members of the military that themselves go on to naturalize if they're not already U.S. citizens. There is a small percentage of U.S. service members who are immigrants who serve in our military and our armed forces who do go on to become U.S. citizens as well. Military immigration is a pretty specific area, but there are special rules that help military members get green cards and visas for their spouses. We can share the link that USCIS has as well, but I can also pull together some resources. Boundless does have a military hub page with information about immigration for members of the military and their families. So we'll make sure we drop those links for y'all later on when we post the video, okay? And I'm doing a last sweep as we're getting into the final countdown here. I think I got everybody. I'm so sorry if there's some questions in there that I missed. But it's always so nice to chat with you all, to give some information out and give updates on what's going on with our system. Please check out our website, sign up for our newsletter. You can follow us on Facebook, Instagram, and Twitter. And we are always trying to update more blogs, more how-tos, more tips and tricks. So just keep your eyes on our social media and we'll keep sharing information. I hope you all have a wonderful day. Thanks for joining me for lunch with an immigration lawyer, and I'll talk to you all next week. Take care.